Hi, this is Chuck Stull looking at innovation in the telephone industry. Telecommunications, like other technology industries, has an important history of new inventions. AT&T and its subsidiary Bell Labs have been very productive. Let me look at a few of their important inventions, starting with the transistor, which was invented in Bell Labs in 1947. The transistor underlies nearly all electronic technology, from computers to digital cameras to flash drives, so this is really a fundamental building block of the modern age. But it's not just the transistor. Bell Labs has a remarkable list of inventions. Cell phone, invented in 1947, although not installed until 1970 for the first time. Solar cell, invented in 1954. Laser, invented in 1958. Communication satellites, invented in 1962. And then programming languages like Unix, C, and then later, around the time the Bell system was falling apart, C++. Bell Labs had over 6,000 engineers and scientists working on research questions and won 8 Nobel Prizes. Now we can look at the economics of a new invention. What is its value to society? And this is something that you are already familiar with. We could look at the benefits to the consumers, shown in the demand curve. The benefits to producers are going to come from the revenues that they get. And really, we're going to look at the profits or the producer surplus. And so the net value to society is going to be the consumer surplus, in this case shaded in blue, and the net benefits to producers, producer surplus, in this case shaded in orange. Now, there are going to be more benefits the more users they are, and the more unique or more new an item is, the more different it is, the bigger the demand will be. And the lower the cost will also increase the total triangles of consumer and producer surplus. And those AT&T inventions had huge social benefits. Now we should think about, we should think about the incentive to invent. Why do companies spend millions of dollars on research and development? Some of it, of course, comes from the profit from selling the product. They want to get those producer surpluses or the profits. Now, if others can freely copy the product, the new invention, then the profit for the original inventor goes down. Now, that may be good for consumers because we'll have a more competitive market, but it does create less incentive to produce. Essentially, if others can copy, then we have a public goods problem. The other firms can free ride on the new ideas. And that, of course, leads to less incentive to invest in innovative research. So intellectual property is a response to the problem of free riding on inventions. And in this case, we're looking at patents. So patent is one type of intellectual property where the government gives exclusive use of a patented idea. And that creates an incentive to research because it means the company can be free from concern about copycats. Now, to be eligible for a patent, ideas must be new, non-obvious, and useful. There's an application procedure to the U.S. Patent and Trademark Office, and it's a lengthy process and often quite expensive. Now, patent protection can be fairly broad, but it is for a limited time. Currently, a patent expires after 20 years. At the time of most of those Bell inventions, the patent period was only 17 years. Now, AT&T had a broad portfolio of patents. They had over 12,500 patents granted to the company. So it was a very innovative company with a very valuable portfolio of inventions. Inventions that could be licensed, ideas that could be licensed to other firms, and patents, like other properties, can be bought and sold. If we consider patents and antitrust, we see two areas of law that are in direct opposition. While antitrust laws intend to prevent monopoly, Patents are in direct opposition, explicitly creating monopoly. And there's been tension between these areas of law. Cases about patents and antitrust have reached the Supreme Court, and the U.S. Supreme Court decisions have generally favored patents over antitrust. For example, General Electric faced a price fixing charge in the 1920s. GE had licensed their patent on light bulbs to Westinghouse, but required that Westinghouse charge the same price for light bulbs as GE did. Now, this seems like a very clear Sherman Act Section 1 violation, but the Supreme Court decided that patent gave GE full monopoly power and that sharing it with Westinghouse didn't lead to any additional consumer harm, and they were found not guilty. Patents essentially promote dynamic efficiency, right, the gains from innovation and progress at the expense of short-term monopoly inefficiencies. So there's an explicit trade-off. We accept elevated prices now, monopoly prices now, in order to reward invention and encourage progress. Now, the system isn't perfect. Only the first inventor wins the patent. So Elisha Gray also invented the telephone. He filed on the same day as Alexander Graham Bell, but Bell got the patent. And that meant that Gray could not even use his own ideas. Now, Gray did start a business manufacturing telephones called Western Electric, based on his own research. But he lost a court case due to Bell's patent, and Bell acquired Western Electric in 1881, and Western Electric became Bell's manufacturing arm. Now, there was concern about Bell's power. AT&T was a regulated monopoly. They had many valuable inventions, but there was concern about Bell being able to spread its monopoly into new sectors, including, at that time, the brand new industry of computers. And so the Department of Justice had been concerned about Bell's power and had filed a Sherman Act case in 1949, looking to separate Western Electric. And because the Korean War action was delayed, but in 1956 there was a consent decree. So this is again the negotiated settlement, a very frequent outcome of antitrust cases, that AT&T could use its new ideas in the phone industry, but not for general manufacturing. So Western Electric could make phones and phone network gear, but they couldn't get involved in other kinds of business. In order to spread the innovation, AT&T agreed to compulsory patent licensing, at a low royalty rate, 2.5% or even 0%, and that they would would maintain those low rates and provide technical information. So this agreement, while it did not break up AT&T, it did lead to really important changes in the technology industries, and AT&T did end up facing more antitrust cases that we will look at in our next video. But that consent decree really was an important policy. Because transistors underlie most modern technology, including computers, in an industry we'll look at next week, AT&T's inventions led to significant innovation and structural change in a wide variety of industries. Now, in some cases, AT&T didn't implement its own inventions in the telephone industry, and it wasn't until we saw structural change in telephones that came not from technological invention, but from policy. And we will look at those in our next video. Thanks for listening. This has been Chuck Stull from Kalamazoo College, talking about innovation in the telephone industry under the Bell telephone era.